There are other instances where we see guardians imposing restrictions or taking certain rights away from the individual, where it's because the guardian wants to substitute their own wishes, their own belief systems, their own views or attitudes in place of the individual's. And we really have seen, unfortunately, examples of that where it goes into the inappropriate and unlawful. They are overstepping their bounds and they're exercising an authority that they don't have, and they're violating clients' rights in the process. So it could pop up in the context of visitation, right, where I'm not allowed to have people in my own apartment or in my home that I want to. More recently, it's popped up in the context of vaccination. The individual wants to be vaccinated, the guardian is opposed to vaccination. Who gets to decide? We would take the position that absent a specific restriction or a court order on this, it's the individual's right to obtain that vaccination, especially because during the pandemic, vaccination has been a precursor to you exercising other liberties or freedoms, like the ability to go into stores or sporting events, or to go back to your day program or to your job. If you aren't vaccinated, it can limit your opportunities. And who should be able to make that decision? Absent a specific order taking that away from the individual and giving it to the guardian, it should be the individual. A handful of years ago, we had to get clarification around the question of voting rights. If a person is placed under guardian, do they automatically lose the right to vote? If they don't automatically lose the right to vote, does the guardian get to make the decision for the individual about whether they vote or who they vote for? It was clarified to say no. Unless that right is explicitly taken away by the court, it's not taken away, and it's retained by the individual, which was an important clarification because, again, we're talking about a fundamental right. And we really try hard through these protective services and systems that we create not to take fundamental rights away from individuals. Other areas of deeply personal issues of autonomy for the individual, sexual orientation or gender identity. We have oftentimes seen over time conflicts between who the individual perceives themselves to be and who the guardian wants that individual to be. That's not the type of thing that typically gets addressed when a guardianship is first imposed, but it's also not the type of issue, fundamental rights kind of issue, privacy issue, that is supposed to be transferred from the individual to the guardian. And there are all kinds of ripple effects that can obviously follow that kind of decision-making, that kind of conflict. And so occasionally an office like the Ombudsman's office will get a call from an individual saying, I am not able to have this relationship, I'm not able to seek this kind of therapy, I'm not able to obtain this kind of surgical intervention or this kind of medication on privacy grounds because my guardian disagrees with me. And that creates the problem that we then have to address. Conversion therapy is a serious topic out there right now, whether the guardian can impose that upon the individual. In most instances, fortunately, the systems have said no. And in many instances, it's led to more systemic kind of advocacy. On a more general level, we have seen instances where, again, it probably falls more into the overprotection category, where the guardian wants to limit the individual's exposure to people, systems, potential concerns or gray areas where the guardian thinks the individual might be vulnerable. We've received calls like that. Sometimes we do get those calls from the guardian. The guardian realizes the limitations of the guardianship order and doesn't think the guardian needs to be involved in the banking, doesn't need to be on the account or be the principal account holder, and gets annoyed with the bank's insistence that somebody else hold the account, and that can prompt a call. Same can be true with almost any system. It could be buying a car. It could be going to a doctor's office. Who gets to make the decision? Well, that can depend on what the third party thinks in practical terms. But those conflicts can result in calls as well. We do ultimately get calls from individuals who they've kind of had it with the system. It might not be specific conflict with the guardian, or it might be. It might just be the inability to go through day-to-day life without being held up by one of these entities that have lower expectations about your abilities and autonomy and want somebody else who's easier to deal with. And so in those circumstances, people will oftentimes ask the question, is this a lifetime sentence? Do I have to continue on with this, or can I get this changed? And there are ways that you can either modify the guardianship or be what the system calls restored to competency. Basically just you're acknowledged to no longer need that level of protection that a guardianship provides. And so there is an opportunity for you to go back and file a motion with the court to change the order or to eliminate it, to restore yourself back to your own self-autonomy, your own level of legal competence in the court's eyes. And so we will oftentimes provide assistance to the individual to help them understand that process. We don't represent individuals in the guardianship process, but there are a number of places that the individual can go. They can go to self-help centers that are set up in judicial centers around the state. The court's own website has a lot of guardianship information to help them understand forms that they can use to help understand how to go through that process. There are advocacy organizations that help them go through that process of modifying the guardianship or restoring them to competency.